No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
Good morning, you're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count 1 in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count 1 that he pled to was the count where he was arrested for a burglary of habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
Go ahead.
So you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review, have corrected them in 7 and 8, I believe.
Okay, so
That's
there
why
was a
it's
first amended.
Yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those please don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count 1 alleges that you were arrested. Okay, so did you want to?
Abandon 1 and 2, Judge, and show that they're correctly reflected in the First Amendment 7 and 8 committed.
All right,
That's
so,
what you didn't like the arrested for last time?
well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay, so 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
True or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true?
Yes, true.
Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025, you tested positive for alcohol. And is that true or not true?
Yes, true.
Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true?
Yes, true.
And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true?
Yes, true.
Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the rich street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would.
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substance Act.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true?
Yes, true.
Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, no.
And because they're actually true.
Yes, no.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay,
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimmler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I can do that, but she has not been cooperative with me.
okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove that up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but so go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we order him to ISF, I will file a dismissal today so that doesn't hold him up. If that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
Cognitive track or substance abuse, Your Honor?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking, moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. Or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
Ronia.
I'll represent the court.
Veronia Parkerson. I'm asking him. I'm asking
I
him.
understand that she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
He is not.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you want to have her brought in?
Oh, we can just have her brought in.
Would you please call the name Aronia Parkerson?
So, drug substance abuse.
If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamel?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamel?
Yes, ma'am.
Your Honor, may the record reflect that the witness has identified the defendant in this hearing?
The record will so reflect.
Judge, on Saturday, April 26th of this year, at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made?
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but the first time they were called, he was trespassed. And the officers explained to me that if I called them back, that the trespass warrant will be voided. I was okay with that because I knew I was gonna call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through a lot. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also in my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby?
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point I started recording a video just to get him away once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay. And is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lavelle?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
And has he pressured you or made you any promises or coerced you in any way?
No, ma'am. I did this of my own free will.
And do you understand that if those charges are dismissed, they're not going to be refiled?
Yes, ma'am.
And that you are taking your safety with Mr. Lamel into your own hands?
Yes, ma'am.
And are you asking the court to follow any agreement that she decides to make with respect to sending him to some substance abuse treatment, so that hopefully when he gets out, your relationship can be more productive
Yes, ma'am.
and he can help you raise those babies?
Yes, ma'am.
Thank you.
No questions.
Thank you, ma'am. You can go have a seat. Okay. Not a good way to handle that situation, was it?
No, ma'am.
When you hear it out loud, how does that make you feel when you hear out loud what you did that night?
A little disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
Right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same.
Okay.
I'm sorry.
I'm sorry. I
Yeah, no, you're not going to get all of this again. Does that make sense? You're likely going to be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So, probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations, okay? All right, good luck to you, sir.